attend this session, and we believe that we will really interact and be better than we came. Uh, just to interact and be free as much as we can. Otherwise, thank you. I look forward to very creative engagement. Thanks. Back to you, Donna.
Okay, thank you, Thomas. So today we'll be doing legal writing and drafting. Before we start, maybe just to know from two people, a male and female, how KSL is so far, project work, classes, everything. Male and female, volunteer, just tell us how you're finding KSL so far. Shikule, you're then muted. Maybe you can tell us something. Shikule E. Lois. Guys, feel free and talk. Ndo tuanze. Anyone. Brenda Nyamwaro. Are you guys hearing me? Am I audible?
Yes, you are.
Thank you for that. Yes, Jen, you can go ahead.
Also, hi, am I audible?
Very audible.
Okay, so for me, I think legal writing and drafting is not so bad. The classes are not so hard to follow. Yeah. What I've noticed is that our lecturers are just insisting on using plain English. Yeah. And then the project work questions are covering what we've been taught in class. I think we've done, what is it called? I mean, the things they've asked in the project work, we've covered them in class. So it's not that bad in my opinion. Thank you.
Thank you for that insight, Jane. It was good hearing that legal writing is good, and I hope KSL is okay with you so far. Jen.
Yeah, things are starting to get hot, but I'm managing.
You'll be okay. Don't worry, itakuwa sawa. It's all just a matter of time, and you'll be done. So today we'll be going through legal writing and drafting, and as Jen has said, which I'll presume is a sentiment shared by most of you, that legal writing is fairly easy. Let's not say fairly easy, but it's something that you can understand because it's just how you draft and how you speak as an advocate or a lawyer. You see, and there's the use of plain English, as she has said. Someone has said something. Starting to get hot. Yeah. The race already started. You're just in the middle of the race, so don't give up. And as I said in our initial session, try and get what? I've lost the word. A support system. Support system can be your family, can be your friends. Don't suffer in pain, and make sure you get enough sleep, take enough breaks. Yeah, going to get hot, but it won't be hot forever. It'll cool down, and you shall overcome. Yeah. So legal writing is fairly easy. It is just speaking plain English, drafting in plain English, Yeah, so today we're just going to do a run through of the of the unit as we've been doing others. And since it's not very wide, we won't really take long today. Yeah, so we'll just start maybe from the first classes, though I don't have your course outline here, but mostly the first classes deals with plain English, which even in exam you'll come to find plain English, that write this in plain English. I hope everyone here has had a chance to look at the paper that we did. Legal writing is easy ikikuja kwa kusoma, but when exams come, sometimes it becomes not so easy. So you have to be very keen with legal writing, because they look at those small things. Yeah, situation, what, yeah. So with plain English, just avoiding grammatical mistakes, not being verbose. You know, the way we advocates like using the strong terms like therein, herein, wherefore. So in legal writing, you're not supposed to use those. When you talk about plain English, it's like someone is telling you, explain to me this, how you would tell a class 1 this. Yeah. So that it's something, when you say a word, or when you draft something or you write something, it's something that thing can be understood by a lay person. And even some judges actually prefer the use of the plain English. There was this judge who came to talk to us. I think it's Mabe or someone. I'm not sure. Yeah. So basically, there's really nothing much to say in plain English, because it's something you understand. Not being verbose, being clear, you know. Yeah, those are things that I think you did in the first classes. Yeah, even in exam, if it comes, it will just be like, oh, not that. Okay, you won't be asked maybe the plain language movement. No, they'll ask you to write sentences in plain English. So make sure you look at the past papers so that you can understand that. And also in legal writing, we have now the structure of sentences, paragraphs. What else? I can't even remember. Yeah. And then there's also the aspect of active and passive voice. Those are things we did back in primary or high school. I don't know, back in primary or high school. So you'll have to revisit all that. You understand what is active voice, what is passive voice. When do we use active voice? Sorry, which one is more preferred in legal writing? Is it active or is it passive? And it is active. And then you have to know the instances when passive voice is preferred to be used. Yeah, so that's it for plain English. There's really nothing much. They're fairly easy things to understand. Maybe Lim, you can give your input on plain English. Yeah.
Yeah, thanks, Donna. I think you have just summarized almost everything. Maybe it's just overdoing what you have said, and maybe most of the time in the question they may not ask you direct questions, and that's why it is important that you interact with the previous papers. But generally, when you are like the first topic, it's normally, and you must have noted that they are just introducing what legal writing is, and of course legal writing in the sense of using plain English, right? About the qualities and all that. When you get to appreciate those things and understand them, then if a question is set, then you will know what they will be testing. So you'll realize even when you will learn about the rules of plain English. Then in a question, they will not tell you state the rules of plain English. Probably they will give you a paragraph and they will tell you to write it in plain English, but you can't write it in plain English if you do not know the basic rules of plain English, because that is what will help you to come up with a paragraph in plain English. So, in short, get the course outline. What we are giving you here is a course outline, but in a disorganized manner, so to speak. I am using that word in quotes. But it is good if you have that course outline, you look at it, and then it will guide you in your revision. But as we delve deeper into this discussion, we will actually collectively appreciate the qualities of good legal writing, the qualities of plain English, or the characteristic of plain English, the difference between plain English and legalese, all those kind of things. What is gender neutral? Examples of gender neutral, um, gender neutral language. All those kind of things we will try to help each other. I'm using that word, try to help each other, because I don't want us to go like you look at us like we know. That is not the case. We are just sharing what we know, so that if we can contribute to making your life easy at KSL, then that will be good. But it is doable. One thing I need to emphasize is this: legal writing is easy, but if you are not careful, it's the one that you will find you have been caught up with. Unlike the 4 C's and the P, which are very strenuous, and therefore we tend to put a lot of emphasis there and get it from the word go. But legal writing is easy. The tendency to ignore is very, very high. And when you ignore it and then time is not there, then you realize the last day you don't have time. And then you go to the paper, you get frustrated, not because you don't know, you are familiar with the question, but because you have not grasped it the way you would have wished, then the frustration sets in. So it's one paper that you have to be very careful. Don't ignore it so much. If anything, just be deliberate. And for those whom we were in the last session last Saturday, I kept on saying, let's be creative in our reading. If you become creative in our studies, when you are reading, trust me, you will enjoy life when those CLE papers come. Yeah. I think that is the much that I can talk. I think many things Donna just say them in passing, though not in an organized way, but that is the work that we need to do here. And then we encourage each other to go and probably follow the course outline the way it should be. Yeah. Thanks, Donna. Back to you.
Thank you, Liam. So yeah, as he has reiterated, LWD is fairly easy, but yet if you're not careful, it may become a very difficult unit. And for plain English, there's I don't even know what to say about it. Or does anyone have questions when it comes to areas of plain English and qualities of good writing, etc., those first topics? Anyone with a concern or a question? So yeah, there's really nothing much when we talk of plain English. So you have to ensure you use gender neutral languages. Don't use very long sentences. I've not managed to see your project work, but I think maybe there are questions to that line of maybe write this sentence in plain English, or gender neutral, or just something. So make sure you look at those, and even when you'll be doing the draftings and other units, they encourage you to use plain English, because we lawyers, we love verbosity. You have to say maybe a sentence in very, very many words, so that you can sound learned, like the learned people that we are. So LWD basically discourages that. You use the shortest sentence possible to convey your message, and then you use just common words. And there's this tennis we normally use herein, reasons wherefore, whereof. Yeah, in LWD, you forget all that and go back to speaking the basic English that you were taught, the one that you can speak to a class 1 year child. Yeah. Yeah, so that's it for that. And what else do we have? So basically, when it comes to legal writing, you go and look at the structure of sentences, the paragraphs, like how long should your paragraph be? There's this topic that is not normally taught as much, transitions. So you can look at that too. It's just part of English, the types of transitions and examples of each. So that's homework to you people. And then the other thing is doing a case brief. Have you people done that? Any class that has done case brief? Ama, how far are you with LWD, if I may ask? Hey guys, am I alone?
Donna, the last thing we did for me, I'm in class G, the evening online class. The last thing we did in LWD was that case brief. That was the last thing we did last term.
Oh, you guys started another term already. I don't even know the
Yeah, we've
calendar.
started another term this week.
Oh. So basically, we really won't go deep into it because ni kama hamjanini sana. But maybe since you guys had started on case briefs, we can just get it from you people. What do you understand? What is a case brief to you? Anyone? Feel free. You can raise your hand. You can just unmute. That will be okay. Eda Shikule. What do you understand by case brief? Guys, you have to cooperate for us to move on. Isikweni kama we are
Hi.
just... Hi.
I think it's just a summary of a decided decision or a case or a judgment, depending on whichever you've been given. So basically, you're just supposed to bring out the issues that came up from the case in summary form. So you bring out the issues and break them down up to how the judge or magistrate came to the decision.
Thank you for that, Eda. So as she has said, in a short term, case brief is basically a summary of a decision. So the decision can either be a judgment or a ruling. So it is a summary of that decision. So why do we need to have a summary? We'll just give any person a chance to give us one reason for why we do case briefs. Why? Anyone? Hilda Wasike.
Good
Mumbi.
evening.
Good evening, Hilda. Good evening.
Okay. For me, I think the reason why we do case briefs is to get the reason of the court in rendering their decisions.
Pardon?
Okay, I'm saying the reason case briefs are done is basically to understand the reasoning of the court in coming up with a decision. For instance, a judgment.
Yeah, there's
Yeah.
a part that you'll have to do the reasoning, the ratio decidendi, depending with which school you came from. Ngugi Peter, another reason of doing case briefs. Ngugi Peter. Ng'ang'a Macharia.
Good evening. Can you hear me?
Yes, you're audible.
Okay, so I believe one of the reasons we do a case brief is to get, for example, in the event that you're doing research, it will help you to get the flow of why the judge or the court came to a certain decision. So you'll analyze it from the facts, from the issues that the court found relevant for determination, and then you go to the analysis. So you'll get a flow. So for your research, you'll get from the top, you'll get a general or a well outlined path that the court used to come to a certain decision. Yeah.
Thank you, Ng'ang'a. Yeah, cases are normally long, so I mean some judgments and rulings are normally very long, so you'll be able to get a flow when you do a case brief. You'll be able to get a flow of a decision. Coach Vincent, another purpose of doing a case brief. Coach Vincent. Martin Gitonga.
A case brief enables you to understand the principles of law set out in the decision.
Yeah, that's true. You get to understand the principle of law. So normally it's said that some laws are made through judgments. So it may set up a principle, for example, a principle that is set out in these locus standi cases. Sorry, not locus standi, locus classicus cases. For example, what principle do we get from the Taquant's case, or what principle do we get from dinner management? You see, yeah. So you'll be able to, while you do the case brief, you'll be able to know to get which principle that this case has brought about. So just in summary, first we get to understand the court's opinion, like why did the court come up with why did the court finally arrive at this decision? So that will give us now the ratio, like why, and the rules that they used to come up with that decision. And it also helps you come up with an argument for your client's case. So for example, you're doing a research or you're doing submissions and you have a very long case. When you do a case brief, you'll be able to find out more about that case and if it supports your client's case. And to also respond to a specific question. So you may be asked, for example, which principle did this case come up with, and maybe which law was applied when arriving at this decision, or what was the judgment in this case. So you'll be able to respond to that question when you do a case brief. And it acts as a reference tool. Yeah, so you can refer to it because, as I said, judgments sometimes are very long. And when you summarize it, you can just come back to it quickly, get what you want, and yeah. It also helps you to memorize, because when you're doing a case brief, you'll go through the whole case while you're doing the specific parts of the case brief. And so you'll be able to remember that, oh, in this case, while I was doing the case brief, and maybe the issues for determination were this, or yeah, such things. Yeah, so those are the purposes of doing a case brief and a brief introduction on what a case brief is. Lim, do you have something to add to that?
Yeah, thanks, Donna. I think you have given what is material. Maybe just building up, and as a way of just taking us back to when you're doing the introduction to legal writing, legal writing most of the time is it's a question of effective communication. And you see, when that is the essence of it, whether you are doing it orally in the form of submission, you are submitting orally or in writing, the question is, are you effectively communicating? And that's one of the reasons why we are using a case brief, so that we can communicate effectively. And you remember, effective communications is entirely three things. One, you are getting the information. And most of the time when you are an advocate, you are getting the information from the witness or even from a reference point. Now, when you are getting that information, how will you present it? You can present that information in the form of a case brief. So that is one thing. The other thing is, if you are not getting the information, then you are explaining. And who are you explaining to? You are explaining it to your client. Again, there, a case brief will help you explain to your client, maybe the judgment from the court or the ruling from the court, you explain it to your client. So when you are doing that, the case brief will make it easy for you. Or you are making a point to the court. When you are making a point to the court, actually, again, the case brief will make your work easy. Those three things make you an effective communicator, because those are the interactions that we do most of the times when we are an advocate. We are either getting you are getting information from the research you're doing, or you are getting information from a witness. And you have to get it in a very nice way that will be so easy for your audience. Your audience may be the judge or whoever. Or now you have to explain it to your client, or you have to make a point to the court in a way that you can capture the imagination of the court. So I think those three things, a case brief will really make you achieve that aspect of being an effective communicator. Yeah, thanks. Donna.
Yes. Thank you, Lim. So yeah, it's true. Normally with legal writing, whenever you're communicating, whether it's orally or in writing, there is an audience that you must consider, so that when you're maybe talking, are you supposed to use a formal language or informal, and how should you grind that information? Like, should you use very plain English, or if it's a fellow professional, will you be using the jargons that they can understand? Not the extreme Latin jargons, but these common ones that they can understand. So yeah, thank you, Lim, for that. So when you're doing a case brief, you need to first read through that case. This the steps or the process of doing a case brief. So you must first read through, get to understand the basic components and the basic facts. So identify the basic things like parties, the name of the case, the court, whether there was something that happened procedurally, you see. So after you first read through, and then you identify the basic first, so that you know who are the parties, what is the name of this case, it was before which court, what is the case number, yeah, and then come up with issues. Identify the issues that were in that case. normally in every ruling or judgment, there must be an issue for determination. The court does not act blindly. It must have something to determine. So there are normally those questions that some are in the form of whether the what, whether the defendant did this, you see. So identify those issues. It will help you know what is in dispute, that is together with the facts. And then which law is applicable, which law did the judge or the magistrate, the judicial officer use when deciding this case. And then their holding, what was their answer? So holding basically gives you the answer to the issues. So maybe the court held that the defendant was this. So for example, maybe a question of whether the defendant is liable, and then the holding will be the defendant was found liable. So that is the answer to that issue, which is basically the holding. And then now there comes the reasoning. So reasoning is why was the defendant or the person found liable for committing something. So it will give the reason, maybe it will be based on the evidence and the law and everything. Up to that, do we have any questions on case briefs? Not case briefs generally, but until where we have reached. Yes, Gitonga.
I have two questions. The first one is that on the issue of, for example, if a judge finds 7 issues for determination, what about in your case brief? Are you going to list down the 7 issues, or are you going to narrow down the issues? And the second question, you have given us the steps. It's my question, do you have to include your opinion on the ruling or on the decision of the judge, or is it not compulsory?
Pardon the second question.
The second question is, you have just told us the steps of briefing a case. Now I have a question. Do you have to give your opinion on the ruling or the decision the judge gave, or is it not compulsory? Because somewhere I saw from the case that you give your opinion.
Okay, so for your first question, if there were 10 issues for determination, so you know the issues are basically what is in dispute, like what is this court deciding on. So you can't narrow, you can't summarize the issues. You have to put the issues as they are. If there were 10 issues, you have to list those 10 issues, whether this and this and this happened, whether this and this and this, whether the defendant is entitled to cost, whether, you have to put all of them. You don't summarize, because if you summarize and maybe merge issues, it will be like you came up with your own judgment. Yeah. So for issues, you can't summarize. You have to put all of them as they are. And for each issue, make sure you have a holding, because a holding is now the answer to that issue. So each issue must have its own holding. And for the second question, you asked whether it's right to give your opinion. Yeah, it is. I was taught by Mrs. Kungu, and she encouraged, even our project work had that. It's encouraged that you give your opinion. What's your view after having done that case brief? What do you think of these judges or magistrates' reasoning? So it is okay to give your reasoning. Limling, if you can add something to what Gitonga has asked.
Yeah, just to emphasize, Donna, maybe if I got Gitonga right, was in the context of an exam. And most of the time, legal writing is more of the form. So I think probably you'll have to rank in terms of which issues are more important or something like that, so that you can probably minimize and meet the target number of pages or something related to that. So if the issues are 10, I don't know. Okay, I agree with Donna. but look for a way where maintain the issues, but then when it comes to areas where you can trim some things so that you can get the right number of pages, please trim those areas. Then the question of an opinion, that is very important. You have to remember court decisions generally, it's either maintaining the president that has been there or going against that principle, and it depends on your argument and where you stand. So if you agree with, from the reading, you agree with the judgment of the court, it is good you state that you agree. And if you have something that you feel probably should have been added, give your opinion. I mean, your opinion is very important, because that's why you are writing a case brief. In as much as you are summarizing the details, it is also important that you give that opinion. I think most of I was in the G class, and that emphasis was also there. So I fully agree with Donna, and I think from the little knowledge we got during that time, we used to envy their class, because Mrs. Kungu is like, she's good when it comes to the question of legal writing and all that. So if she advised that you have to have that, you can actually depend on that advice that she gave. But all lecturers really advocate that you put your opinion. And after all, it is a case brief, so you must really have your opinion there, whether you agree or not. Yeah.
Yeah, Gitonga, I hope we've answered your question. Like, it is not mandatory, but according to Mrs. Kungu, what she told us, that can earn you marks, plus, it shows you understood that case, and you're able to now give your own objective opinion of what you think about that decision. Plus, you won't be penalized. For example, in our project, we were doing a case brief on the LGBTQ case. So, in that case, the people who will be like, yeah, the court was right. The court was right. Or, LGBTQ rights, I don't know what. Or someone will be like, LGBTQ should not be allowed, you see. So you will not be penalized for having an opinion. It is actually a very good thing. And you have to be aware, if you're told to limit your case brief to a certain number of pages or words, you have to ensure that if after you include all the important parts of that case brief, and ukipata space, you can come up and put your comment afterwards. Are you satisfied, Gitonga?
Yes, I'm very much satisfied. Thank you.
Yes. So those are the minor steps for doing a case brief. Any other question? Any other question before we proceed to the structure of a case brief? Okay, so I'll presume we are Jen Ogalo.
Also, I have a question. So we were told in class that generally, like when we are given any work, we should avoid having many subtitles, like the way a case brief has facts, holding issues. Like we were told that it's not necessary for you to like highlight holding brief every time you are writing it. So like, how would you advise us on that? How should we approach it?
Well, the opinion, especially when it comes to case brief, you have to show that, these are the facts. So there'll be that subheading, facts, and then the issues. Because imagine maybe you have now the case name there, and then in the facts, they are normally procedural facts and substantial facts. So you just maybe have a heading, substantial facts, and then you proceed through the substantial facts, and then you do the procedural facts without having the subheading. So whoever will be reading that will proceed knowing that this one I am still reading substantial facts, but what are the procedural facts doing within the substantial facts? So when it comes to case brief, I think you should label, and that's what you actually told. You have to label that now these are the issues, this is the holding, but there was something I can't remember. But you have to label to show that this is to differentiate, for example, the judgment from your opinion or the locus from your opinion. Your own opinion or comment comes at the very end. So if you put that together with part of the case brief, like those components of the case brief, I think it will bring some confusion. So in that aspect, you should label that these are the procedural facts, these are the issues, etc. Lim, what do you have to say for her question?
I can only add this. For the project work, follow the instructions of your course instructor. Otherwise, what Donna said, I stand by that. Thanks.
Yes. Yeah, actually, that is very true, because it is your lecturer who will be marking your work, and something like probate, if you listen to Anastasia and bring what Anastasia says to Miss Ruto, you will suffer. So just listen to your course instructor. But ikikuja kwa exam, you're racing against time, but you have to ensure that the essential components of that case brief are known. But further units and other draftings really don't have too much unnecessary subheadings and topics, unless it's very necessary. That's when you should have. Is that okay, Jen?
Yes, thank you.
Karibu. So we'll do the structure of a case brief. Maybe we can get it from the class. Anyone who can tell us a structure, maybe from what you've read or what you've been taught in class, the structure of a case brief. Akinyi Faith.
Yes, good evening.
Good evening. Could you tell us the structure, just an outline of how a case brief should be?
In my opinion, it ought to have an introduction where you could maybe give a brief summary of what the case is all about in totality, and then maybe the body, where you now analyze each issue as it has been pointed out in the case in detail, and then you conclude by maybe giving your opinion to what the case entails. Yeah.
Thank you for that, Faith. Abdullahi Amina. Kimathi Kanana. Pascal Mailu. Yes, Kimathi.
Can you hear me?
Yes.
Okay, so from what I can remember, there is the introduction, okay, not introduction rather, but the issues. And we were told in the issues there is the factual issues and the legal issues. So you sort of give a summary of those issues that are arising, and yeah, you summarize them, and then the rule of law that was applied by the courts, and in addressing those issues that you have identified in terms of the fact-centered issues and the legal issues, and then the holding of the courts upon applying the rule of the law, and then judgment, and then reasoning of the courts. And then from there, we were told, okay, those are the main ones that we were taught. But we were told at the far end, the other factors that are considered are things now like, was there any dissenting opinion, any concurring opinions, and then now your opinion on the case.
Thank you, Kimathi. Last person, Jenga Samuel. How do you think the structure of a case brief should be? Jenga? Nyongesa Solomon.
Okay, in my opinion, I think a case brief, I think in my understanding, it is the summary of the case plus the whole judgment. So in summarizing the case, I think you summarize the facts of the case. And in summarizing the facts of the case, you can have a small introduction, the body, the conclusion, and the whole judgment of the case. Okay, thank you for listening.
Thank you, Nyongesa, Kimathi, and and Faith. You have highlighted some of the things that should be in a case brief. So when you're doing a case brief, the first thing, we have to know which case is this. So you need to have the heading, like the case name, who are the parties. Donna versus X. It was before which court. So normally the way the heading is normal inakwanga, where we have Republic of Kenya, so that may not be necessary, but then you have the parties. Who are the parties? This versus this. It was before which court? In the High Court at Mombasa, or in the magistrate courts, or in the Supreme Court. You have to state that. And then the case number must also be there. So that is the very first thing, because you can't give a brief of out of the blue. We have to know which case are you briefing us on. So that forms part of the heading. And then now we'll go to facts. So normally for facts, there are substantial facts and procedural facts. So substantial facts are actually what happened in that case. Like before, what happened so that this person came to court. So you have to give them briefly, you summarize that, and then you do a procedural history. So procedural history are basically what happened in the course of the case, because you'll find maybe someone made an application or something happened in between the case, yeah, or a ruling was given, or maybe someone sought an injunction and it was given. So you'll include that in the procedural history. Are we okay until there? Can I get a sign, guys, that tuko pamoja? Okay.
We are together.
Yeah, so take note. So you have to have the heading, which is, it was before which court, what is the case number, who are the parties, and then now you come and give us the substantive facts, like what happened. Maybe it was an accident claim. This person was driving along this road and maybe was driving recklessly and akaumiza a pedestrian, such things. So that will form part of the substantive facts. And then procedural facts, what after you file the suit, in between the filing of the suit and delivering of the judgment, what happened? Maybe there was an application, and if it's an appeal, you'll include maybe what happened in the trial court, the first appellate court, you see. So that will form part of the procedural facts. And then now comes the issues. So issues are normally framed in the form of whether this and this happened, whether though not necessarily, but most of the time that's how they are framed. So issue is basically what the court is supposed to answer, or what is in dispute that this court is supposed to make a decision on. Those ones, they're easy to identify because in most rulings and judgments, they just written the issues for determination were this and this and this. Just go to Kenya law, search for any case, you'll find that. And then there's the rule of law or the legal principles that were applied. So which laws and case laws were used when coming up with this decision. Yeah, so that's the rule of law. And then there's the holding. So holding, basically, you see we had issues. So holding is an answer to the legal issue, sorry, to the issue. Yeah, so maybe you had 3 issues. So there will be 3 holdings. Like this holding will be answering. For example, the first holding will be answering the first issue. The second holding will be answering the second issue. Yeah. And it is not like what court finally decides. No, it is just an answer to that issue. And then after you've given the holding, you'll give the reasoning. Like, why did the court give this holding? Why did the court hold so? So basically, it sort of marries the facts and the laws to give now the reasoning why the court decided that way. And then now the judgment. So judgment is maybe the accused was found guilty. So that's the judgment. That it is just a small sentence. It is not something that's very long. Yeah. And you should make sure you don't confuse the judgment and the reasoning. Judgment is the final, what the court finally decides. Maybe that this land was legally acquired. That is the judgment. But then there will be reasoning that will come initially in the reasoning or rationale, the ratio, the sedenda of the court. And then now there are the extra things that we were told by one of us, the dissenting opinion, concurrent opinion, yeah. And then now your final comment or opinion on that case. Are we together until there? Hey guys, you people are so
Yes,
yeah.
yeah.
Lim, anything on the structure of a case brief?
Jonah, you have captured all of it. The thing that is normally for I find we get to forget is that aspect of where there is majority opinion and the dissenting opinion and the concurrent opinion. That is where the I find a bit of challenges normally coming. But if you can decipher the 3, then you are home and dry, and you have captured that quite well. But otherwise, the other things are normally straightforward. Jonah.
Oh yes. So do you have a question on the structure of a case brief? And are we satisfied that you can do a case brief? Because it's just basically you read the case, you get to understand the case, and then you put it into parts, like the procedural facts. What were the substantive facts? What was the judgment, the reasoning and rationale? Are we satisfied that we can confidently do a case brief? Guys, what? Anyway, I'll urge you all to look at that. It is actually a question that can be tested, so you'll just be brought for a judgment or a ruling, and then you're told to do the case brief. It's a fairly easy. Those should be free marks because you don't have to take your time to think that maybe I should do this, or you don't even have to give your opinion. The answer is just right there with you. So yeah, that's it for our case brief. Lim, maybe you can guide us next on what we'll do.
Um, um, guys, I think it is good to be very, very, we encourage that you be interactive. If you are not interactive, then it becomes a monologue kind of, and it normally becomes a bit of a challenge for those of us who are on this side now trying to help. So you will be so helpful to us if you really participate. Just to build up, I think on the case brief we are proper, and the most important thing is try to do your own drafting and the critical things. And if you follow what Donna said, is that actually much of the things he said is this rule that is, I don't know whether to call it a rule or the approach. Let me call it the approach. The FILAC, others call Iraq, something like that. I think from LLB, you got to know that in a case brief, other than the question of having the caption, which is the title there, and the question of substantive and procedural facts, commentaries there, I think with FILAC, you just need to top up what is missing there and you are home and dry. Then, since we are doing also the question of introducing, we are introducing this legal writing thing, I think and most of these things the lecturers or our instructors must have told us. And therefore, if we overlook it, we overlook it on those bases. Like probably some of you would have expected that we could take you through the aspects of the qualities of legal writing, something like that. But I think what is more important is, and I did emphasize this last time, when you are reading even the question of qualities, because lecturers must have taught this, like qualities of good writing. Reading is one thing, but committing them to memory is another thing. And that's where the challenge is normally. My experience is that if you have committed the qualities, or take, for example, the qualities of good writing, and you have committed it to your memory, then if a question comes, it is easy for you. So maybe as just a piece of advice, be a friend, I talked of creativity last time. You just be creative. Creative in the sense that, like, you realize, again, when you read plain English, they are categories of words. There is those ones that they call the working words. And then there is the glue words. You will find them in legal writing there when they are talking about the sentences, words, when they are describing words, how you arrange words, how you form sentences and all that. So when you are reading, and this is just an advice I'm giving, identify the keywords that will help you to come up with an acronym, something like that, that will help you. And I will take, for example, like, and Donna alluded to this, that you get your support system. And I think that is the most important thing. Get your support system, even in terms of reading in your groups. get your support system. It will help you. Somebody whom you can rhyme with, somebody whom you can be in consonance with. I'm not saying that you ignore the ones that you are not in agreement, have them also. But that support system will help you in revising. Like, for example, when we were, for my case, when we were doing these things, I had a very good support system, somebody whom we were reading with. And we could identify like the qualities, and then we form a word that is easy for us based on your context. Yeah, like all those qualities, for example, the qualities of good legal writing, for us, we committed all of them to our memory, and we just formed a sentence with words like, for example, I remember us forming a word like club, ile rungu ya Kimasai, because it is something that we could relate with. And that club was giving us majority, actually, we got 6 characteristics there, and the whole sentence, but I hope I am making sense, so that when you identify, you have those qualities in your mind, even when you are given a paragraph that you require to reduce, it becomes very, very easy. Even when you are asked, let's say, for example, now that you are heading to the season of orals, you can be asked, for example, this group, that session will come, the session for the orals. I'm sure very soon it will be rolled out to prepare you for the orals at the end of the term. You can be asked a simple question, let me call it simple, like, what do you understand by effective communication? Just something like that. Yeah, explain what an effective communication is. These are something that you have read, but if you had not been creative in a way that you got what it means, you will fumble and you lose it out. So, and you see, I remember that time when we used to revise, we read there were 3 long sentences that had been provided explaining about I'm just giving this example, explaining about effective communication. And it was difficult for us to get hold of those sentences, all of them. But what we did with my support system, allow me use that support system, the person whom we were reading with, we identified the words that were there, and we got a word called gem, G-E-M, that one. Gem is a minerals, and it is also related with the jewelry that our good ladies put on, and even gents nowadays put on a lot of jewelries, a number of them. So, and we could actually remember that, and we reduced the effective communication to GEM, G-E-M. I'm just giving that as an example. And we could just say, if you can, one, get the information from the witness, if you can explain to your client, and if you can make a point to the court, then you have effectively communicated. And that has never left my mind. That is what I mean, being creative, and that will make your work easy. So in cases where, like now, probably we didn't take you through qualities of good legal writing and all that, and some of you are wondering why, we just want you to, because we come from different contexts, when you are relating with, when you are reading, and when you get your support system, those are things that you will have to employ. Those are the strategies you'll have to employ to get your stuff done. Donna was explaining like the question of case brief. Case brief, without you knowing the component of a case brief, then you can read as many times as you can and you will not get anything. But once you read it once and you get the important elements, like the way Donna has put to us, how the heading should look like, the caption of the case brief, substantive, facts, all those steps. If you can put it in a way that you can remember all of them, so that when you are given a pamphlet of a judgment or a ruling, that thing comes in your mind, so that what you will be writing is just identifying those things and putting them there. You are home and dry when it comes to drafting a document. A contract, the same thing. Just be creative and with that, we will be home and dry. You will enjoy. There is nothing as frustrating as coming across a question that you know the topic, but you cannot write anything. So, but as we continue, we will try to see how we can prepare you for the orals or prepare us. I'm just saying, excusing ourselves because we have already done it. It's your turn, but otherwise we are just more or less the same. We are learning from each other. I think that's the much I can. But if you want, maybe the last thing is this: if you want us to share some of the acronyms that probably we had, we will still feel free to share with you. But the catch point is this: some of the acronyms that we will have may be difficult for you to get all because our context is different. But if you create an acronym that is convenient to your context, it becomes so easy. And you will never repeat reading the same thing again. You'll just learn it and you move. And there is no time. And that's why it is important that you read one thing, do it creatively, and move away from that topic. So that you can save that time. There will be no time to do repeated reading, so to speak. I think, Donna, that's the much I can add for the night, for the night now. Unless there is a question, I think permit me stop there, Donna. Thank you.
Thank you, Lim Lim. I hope you guys have taken note and you can approach him for the acronyms. Yeah, for me, I don't think I had acronyms, but anyway, just approach Lim Lim and get the acronyms. I think I've seen someone like Daniel in the meeting. Daniel, are you in?
Yes, Donna, you called my name.
Oh yeah. You can just say hi.
Okay, thanks. Hi, guys. I hope you're well. My name is Daniel Odur. I think normally you see me in WhatsApp sending texts and sharing links for these meetings. It's nice to have you. I see we are 20 today because I know the 3 is me, Lim Lim, and Donna. And I think all through this meeting, one thing I've struggled with is how people are not responsive. And I'd just like to encourage all of us. You see, for a doctor to treat you, you have to tell them what the problem is. For a lawyer to represent you, you have to tell them what your case is. For you to get the best, legal advice or legal representation, you really have to speak and tell us what the problem is. For these sessions to be, as industrious, as fruitful as they can be, we have to speak. We have to speak. Now, one thing with lawyers is, speaking is our tool. That's how we communicate. That's how we make our money and everything else. And so I think for me, I'd just like to encourage all of us that, yes, we can come here. We can always be here, but it's not important if we can't speak and say, oh, Donna, you said this, but I don't think this is how a case brief should be written. The lecturer said this. What do you think? And how can we mix this idea and this idea? How do you think this can work? And that is what we've done all through these years. And I can tell you guys, it will work. One of the best ways to remember what you're taught is if you had questions after whatever was taught was taught. So it's very important that we ask questions after, these guys have shared their opinion and everything. And it's also encouraging. At least it helps Donna and us and Lim Lim to know that truly we are concentrating and we hear what's happening. Now, I'd like to thank you for joining, and thank you for being part of this team. Thank you for coming so that we are able to share. But yeah, of course, I'd also like to encourage us to let's be responsive. Speak. Donna is not your lecturer. She won't do anything with what you said. Lim Lim is not your lecturer. He won't punish you for anything that you have said here. So let's just have a conversation, because one of the reasons why we have this group basically is just to have a conversation. We just want to have a conversation with you. And it's sad when we can't have that conversation with you. So I don't want to come out as if I'm being harsh or anything, and that is not the intention. But I'd just like to implore us, let's be chatty. Let's be able to say that, wow, these guys are really asking questions. Before I come for the next meeting, I really have to do my research. I really have to read. I have to know what this is about. I just can't come to that meeting and say whatever I want to say. I have to be very thorough with these guys because they have questions. So just to encourage you and just to encourage us as we encourage you, it's very important that we get feedback. It's very important that you speak back to us. It's very important that you ask us questions. Ask as many questions as you want. We are ready to engage you. We are ready to have a conversation with you. We're ready to answer those questions. And that is why you are here. So if there's anyone who might be feeling intimidated, or you feel like, there are 20 people here who you don't know and this and that, I'd just like to tell you that there's no need. We are just like you, basically, maybe not exactly as you, but we just went through this system as you, and that's why we're doing this. We are not lecturers, we're just students like you who are trying to help. So engage us, speak to us, let us know what you think, let us know the questions that you have, so that we are also able to plan these classes better and see what we can give you that maybe we are not giving you so far. So please, that's the encouragement that I have. But most importantly, I'm very happy. I'm very happy to see us here. And Donna, I won't take much of your time because I know you still have much to share. But guys, I'd just like to encourage us. Let's be active. Let's be responsive. When Donna asks a question, at least let's have 1, 2, 3 guys answering. Let's be free. It's a free world. It's 2024. We keep saying this. It's 2024. It's a free world, man. Ask whatever question you have. It's a free world. If you have something to say, let us know about it. Let's be free. Let's talk. Let's have a conversation. So please, the doors are open, even the windows too. Just say whatever you want to say. Ask whatever questions that you want to ask. It will really help us to know how to encourage, how to become better in this session. So please continue to enjoy the sessions. Donna, I think back to you, but it was very, very nice to talk to you guys. I'm enjoying the class. I hope you are too. Donna, back to you.
Thank you, Daniel. And as you said, please let's participate, because it's the only way we know whether what we are doing is actually being understood, or what you are saying is being understood or heard. Yeah, so just give feedback, ask questions, etc. So really, since you guys have done up to case briefs, it won't be fair to go too deep into those are the things that you've not done yet. But one thing you have to be sure of, case brief can be tested, and it may be tested because last year we didn't do that. I don't know if they did that in the April series exams, but the structure of a case brief, how we've told you, you need to have the caption, which has the court, the case number, and the parties. Get your substantial facts, the procedural facts, issues, holding, rule of law, and then the ratio decidendi, or the rationale, the judgment finally, and then now when there is a dissenting opinion or concurring opinion, and obiter dicta, and get the difference between this dissenting opinion, concurring opinion, and majority opinion. Make sure you get the difference and understand, and then you can give your final comment or opinion concerning the case. So maybe other draftings that you'll come across in the course of this unit at the drafting of letters. This one is something very basic, and it is sort of mandatory in every paper. So you may have to do a demand letter or letter to a client. There's also the office memo. So those ones you'll do them later, and maybe if we find time again, we'll do that. And another drafting is a drafting of contracts. Just the contracts, there are some basic features in a contract that lazima zikuwe for it to be a contract. So that is also another aspect of drafting that may be tested. And then there's the bills, which must be tested. Bills, though this is a term 3 work, and you guys will come across it at that time. So for today, we really didn't have much. Plus now we are not sure where you people are. No one is talking. Amongei sana. So we really don't know, but at least we've discussed case briefs. And if anyone has a question up until here, you're welcome concerning everything we've talked about today or anything in legal writing. Any question? We'll have Jen and then Faith. So Jen, you go first.
So I just wanted to ask, maybe if you can talk about writing a research outline, because we've covered that and it's sort of confusing.
Research outline. Okay, that's
Yes.
noted.
And you mentioned that when we're doing the case brief, we start with the heading and then we talk about the parties, case number, court. How do we write this? Is it in a line? I am not really sure, considering my class has not done a case brief yet.
Oh, you just do it the way, okay, it's the way inakwanga. You can choose to do it that way, like you have the Republic of Kenya, and then before this court, case number, for example, maybe appeal number this of 2020, and then the parties. That's one way. There's you can also just have the name of the parties. I'll send you a sample of what you did for project work. Yeah, so hapo hivyo, as long as you've mentioned so that we know it is this case, maybe in terms of case number and the parties of the case, that will just be sufficient. So you can have it venye inakuanga hapo hivyo kwa caption ya pleadings, Republic of Kenya, before which court. And there are some people who even include, for example, in Supreme, if it were a Supreme Court case, the judges who are sitting, because sometimes they don't sit all of them, maybe 5 judges have sat, so you'll have the name of those judges. I'll just send you a sample of what you did for project work. Apo, I don't think you'll be penalized or there's any particular formula. You just have to make sure that we're able to identify who are the parties in this case. It is which case, maybe case in terms of case number. Yeah. And Jen asked about research outline. Lim, could you handle that?
Jen, if I was to handle it now, I will really be struggling. Can we have it in the next session? Faith, will that be okay?
That's okay.
Yeah, I don't want to mislead you. I want to give you what you can really rely on. So let me have a look at it. You can also have a look at it, and then so that when we'll be giving you, we can actually improve if need be from that. Okay.
Yeah. Okay. Yeah.
All right.
Yeah. We want that a research outline is basically just an outline of how you're doing your research. I think we had such a question in our project work too, and I think it concerns maybe a specific aspect. I can't quite clearly recall whatever we were doing a research outline for, but basically maybe just how you'll structure your work. Let's say it's what was that? I think we were doing some data, a legal opinion, and then we want to do a research outline for the legal opinion. So basically, it is just a roadmap of how will our legal opinion look like what do you want to achieve at the end. how do you want the structure to look like, and what are the components that will include in this legal opinion. So for that, as Limlim has said, we'll prepare sufficiently for it, and then we'll have a class specifically to discuss that together with maybe other things that you'd have handled, especially in terms of drafting, because with LWD, you're always sure that you're going to do more than one drafting. So we'll capture that in the next session. Is that okay, Jane?
Yes,
It
that's
was
okay.
Faith.
It's okay. So for today, is there any other hand raised? I'm seeing there's a hand, but I can't see who. Kimathi and then Shikuku. Kimathi, Lisa, can go ahead.
Thank you. I also on the same, I wanted to ask, now the research outline has to be the same with the legal opinion, like what you provide in the research outline, must it reflect on your legal opinion?
Okay, so from my understanding, but this will be captured much later by Lim. Hopefully we'll have a session as soon as possible. But research outline gives you, it is a roadmap. You see the way your course outline in Akwanga, it is called course outline because it gives you a footpath that maybe at this week we'll be discussing this. So if I can remember in our research outline for that legal opinion, we had maybe a subtopic like now here we'll be discussing the facts, then I'll brief facts of what had happened in that case. Yeah. So we'll just go and prepare sufficiently for this and then get a session as soon as possible, maybe next weekend or after, we'll see. Then we'll get back to you. Is that okay, Lisa?
Yes, thank you.
Maybe just
Yeah,
to
but
add
it's just
to Donna, sorry. Go ahead, Donna.
Oh yeah, I was saying it's just a roadmap. It's supposed to guide you, like when we are doing this opinion, this is what we will be following. This is the structure we'll be following. But these are what we are supposed to have. Yeah, Lim.
Yeah, I'm trying to imagine what, I don't know, was it Tracy that was asking that? Somehow there are similarities when you look at the research outline and the legal opinion, especially when it comes to the question of FILAC or IRAC. But there is a difference, and that's why I intentionally chose to divide to the next class. Probably we can consider it as a matter of priority. There is a slight difference, and it looks confusing sometimes. I remember when we were being taught also, that aspect kept on engaging our minds. So if you can be a little bit patient so that we can get you the exact thing that will be the exact distinction between the two, then that will be good enough.
Yes, thank you, Tracy, to your question. So we'll do that as a matter of priority. We'll get a session as soon as possible to discuss a research outline. Tracy, you can ask your question.
Okay, thank you. So my question was regarding the legal opinion. Taking into consideration the audience that you are writing that opinion to, like let's say if you're writing it to a client, should you like include cases in it, considering like the client doesn't know about case law, or should you footnote it? Like when you want to talk about cases, how exactly do you talk about them in the legal opinion if you're writing it to a client? Perhaps if you're writing it to a lawyer, it would be different. So could you kindly clarify that?
Yeah, that's a good question. So in LWD, you normally have to consider your audience. That one I know you've been told over and over. And one thing, don't put footnotes in your legal opinion. Don't put footnotes in your opinion. And then when it comes to case law, sometimes we use those case laws and laws to make our points clearer. So you can just a lay person will understand that, you know, they understand that we normally rely on decided cases, but now you have to make sure you grind it in a way that they understand. Like maybe in a decided case, this and this and this, the court held as such. And so based on that, our opinion on this issue that you presented before us is this. Yeah. So you can use laws and case laws, but don't use too much of them, because you have to be considerate of your audience. Ataelewa hiki tunasema, and plus, you know, you're trying to legal opinion is used to, is it persuade? I've forgotten, sorry. But yeah, you have to consider your audience. Even if you're using a case law, don't make it so complex. Like maybe you can say, we're looking at this issue, we consider maybe a decided case of so and so versus so and so, why it was held as so, and as such, and based on this, our opinion on maybe kitu court itakuja kuamua is this. Limlim, what's your answer to that?
What was the question? Somewhere I got engaged a little bit, if you don't mind.
When you're doing
Sorry?
a legal opinion a client, is it okay to include case laws? And if you were to do that, how do you incorporate case law in that?
Okay. Again, I think it's all a question of who is your audience here. Okay, that client of yours, is it a layman, or, you know, even a lawyer can be your client. So if it is a lawyer, I think it will be good. You can include a case because, you know, a lawyer can understand. But if it is an ordinary person, I think you don't have to include a case. And most of the time, the questions always, even when they are setting it, they will use examples that will show you, or they will provide a context that will kind of direct you, whether you are handling a lawyer or you are handling a normal person, you will know. So a layman just stick to what they can appreciate and understand with ease. A lawyer, you can throw, I mean, you can put a case, or you can throw one or two Latin words or something like that, because it is a lawyer. It is the context provides this is a learned friend or something like that. That's what I can say. So I don't know whether I have answered the question or not. Who was that?
That was is it Tracy? But yeah, venye Limlim amesema, legal opinion, basically you're seeking to persuade, and sometimes to persuade you have to use case laws. And if you're talking to a lay person, make sure you put that case law in a way that they can easily understand. You grind it to the finest possible words that they can be able to comprehend. Yeah. And ikikuja kwa exam, not exam, let's say maybe if you're doing that for your project, I don't know if you're doing, including a case law you will not be penalized. Watangalia tu how have you used it. Have you made it ikae complex sana yenye huyu msaizi elewa? Because you're seeking to persuade them, maybe concerning a certain direction that they should take. So in persuading them, sometimes you'll need some law or case law, and you can include it or not include it, but just make sure whatever you're communicating, they're able to understand. Is that okay, Tracy? That was Tracy. right?
Yes, thank you.
Yeah. Any other question?
Maybe Lorna, just to add, sorry. All right, I thought somebody was talking. Just to add, in a legal opinion, remember, there is a clear format that has been provided there. So when you are including the law, I mean a case law, remember a case law, it's part of the authorities or the rules that, yeah, because we have the constitution, we have the statutes, and then we have the case law. And in some instances, you can even have the regulations and all that. So you can actually capture them in that part of the rules applicable or the rules section. Yeah, Donna, that is what I wanted to just point out.
Thank you. Jen, you are saying something?
Oh, I wanted to ask another. So we were told that a legal opinion can be a letter or a memo or an internal memo. So I was just wondering, like, how long should a legal opinion be for it to be a letter, and how long for it to be?
Jen, you're not quite audible. Unaweza rudia haukuwa audible.
Donna, she was
Can you hear
breaking.
me now?
Okay. Jen, go on.
Yes. Can you hear me now?
Yeah, we can hear you, but you are breaking. But if I got you, I think you are asking of how long should, okay, the first question was the presentation. What form does the legal opinion take? A letter, an internal memo, and what circumstances determine that? Then number two,
Yes.
how long should it be? I think those are the things I try to scan from, though you are breaking. Is that the position?
Yeah, that.
Okay, Donna, would you wish to go first, or I just throw Nini and then you top up on that?
You can just go ahead and then I'll add
All right.
anything to it.
Okay. Jen, again, the context, it will be made so clear when it comes to what form should, when it comes to the question of what form should a legal opinion take. The context will guide you. Like internal memo, most of the times, actually the rule is internal memos are for organizations. If you are in an organization, then they will give you an organization, like they will say some questions will bring a context of a government institution. Like they will say the governor asked asked you as his legal advisor, to advise him on a particular issue, or to advise her on a particular issue. You see, now that is a context of an organization. That tells you the form that the legal opinion will take. In such a case, it will take the form of an internal memo, because you are in an institution setup. Then they can tell you that a client, you are a lawyer, a client walked to your firm, blah, 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 blah. Then you are told, write a legal opinion to the client. You see, now for a client, it should be a letter. The format that a legal opinion will take is the letter format. So now you will do it in the letter form in terms of, and there will be, there are formats, the letterheads and all that. There is that format that so you'll write it in that form of the letter. On the limits, the question will tell you in using, they will give you the limit. They will say one page later, 2 page, 5 page, they will always tell you the maximum pages that you need to. So you limit your legal opinion to the number of pages that they have asked you to do. No more, no less. So I think that is the best way I can kind of how can I call it? Explain. Yes, let me say it that way. Donna, you can add.
Okay, sorry. Then, the format, to know whether you're supposed to use a letter or an internal memo. So internal memo speaks for itself. It's internal, like you're communicating to someone within let's say an office or an organization, just like Lim has said. For example, you are a pupil in a law firm and your pupil master asks you to give a legal opinion. In that case, you'll do an internal memo. But then consider a situation, a client comes and asks you to give them a legal opinion on something. So you'll use a letter in that case because the client and he's not part of that organization or office. So when you're with someone within the same office, you'll use an internal memo. And as to the, what was the other question? As to the what?
It was the max, the how long should it be?
Oh, how long? Yeah, how long? How long you can be guided by the question, plus here, there are some legal issues that are very complex. You can't just explain in a page, but also don't be verbose. This is legal writing. You're supposed to be as brief as possible to ensure you also have to understand your client, because but most people, especially lay people, don't like reading very long things, and utampoteza at some point because there'll be some aspect of verbosity or being complex. So try use the shortest, the simplest words possible and in the shortest form possible. So you can do maybe 2 pages maximum, give yourself that. If at all you're not restricted, because if it's too long, again, you'll be violating some of the rules of legal writing. Does that answer your question?
Yes,
Jen, I don't know if I'm the only one having a problem hearing you.
I am also having a problem hearing her.
Okay, sawa. Any other question before we close this session for today? Okay, since there's no question, thank you guys for joining today's meeting. We appreciate your input and your participation, and we hope we'll have another session. We're also hoping that you learned something, so just go and practice how to do a case brief. Nani atatufungia kwa maombi? Someone can pray for us and then we leave. Hey guys, adi maombi we? Yes, Faith, you can proceed.
Okay, let me pray. Before I pray, thank you for this session, and thank you for taking your time to take us through legal writing. We really appreciate that. Let's pray. Our kind and ever-loving Father, we thank you for this night. We thank you for this session that we've had. We ask you, dear Lord, to continue opening our intellect so that we may grasp whatever we are studying and whatever we get during discussions. And how I pray that you may also bless the facilitators for today's session. We thank you for their lives, and we ask you, dear God, to bless them in their endeavors, Jehovah. Even as we'll be returning to bed later this night, we pray that you may cover us with your wings. Thank you for, we pray, trusting and believing. In Jesus' name, amen.
Amen.
Thank you, guys. Have a good night.
Amen.
Good night.
Good night.
Thank you.